contact them and let them know
beforehand.
and see.
Nothing upstairs anymore, or not upstairs, but in my bed. So I just had my paperwork and I have it with me. So do I have to go back up to my room at all?
Up to the officers. I don't know how they coordinate that.
Yeah,
Okay.
I was just wondering.
Yeah, but they'll know better than me. I don't have that information. I apologize.
No, thank you so much for everything. So
If you step to your left, the officer will get you that paperwork.
have a good day.
You too. Good morning, Ms. Scott.
Good morning.
Mr. Madrill to the podium and Mr. Bragg to the chair. Can I get your name and date of birth?
Holt Van Madrill, 11/8/94.
Thank you, sir. You are here today on a new case. It is for 1 count of criminal damage, a Class 6 felony, and 1 count of disorderly conduct, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. You will have a status conference August 24th at 8:30, a preliminary hearing August 26th at 8:30. In this case, I am going to release you today on your own recognizance. That is your promise to appear, but you do have written conditions. You're not to return to the scene of the alleged crime. No contact with any alleged victim, complainant, or witness. This will be in your paperwork, sir. Did you have any questions?
Yeah. So I blacked out, so I kind of know where I was at, but it happened at the bus station, right? So am I not allowed there at the bus station anymore? Because I ride the bus regularly. If I have to avoid it, I will. But I'm just trying to figure that out. You know what I mean?
So it took place at 9804 North Metro Parkway.
Yeah. That was the Williams Transit Center.
Okay, and you utilize that often?
Yeah. I ride the light rail, but I mean, if I have to avoid that bus station, I will. You know what I mean?
I'll remove the, you can return to the scene since it's a public place and you may need to go there for transportation. I want to make sure you can still get to the places you need to go. But if you do happen to see the alleged victim, complainant, or witness there, then you need to avoid that area at that time, okay?
Thank you.
All right, we need to get that reprinted, so if you could take a seat in the gallery, they'll bring that out to you.
Thank you.
Mr. Bragg to the podium and Mr. Nunez to the chair. Can I get your name and date of birth?
Jeffrey Bragg, October 7th, 1984.
Thank you, sir. It does look like you are here today on 2 cases. You're here today because a direct complaint was filed, and you're also here on a warrant that was issued from the Hacienda Justice Court. As it relates to the direct complaint that was filed, it has an alleged offense date of February 9th of 2026 for 1 count of dangerous drug possession, a Class 4 felony. In that case, I'm going to appoint an attorney to represent you, and I'm going to give you 2 hearing dates. These hearing dates will take place in the downtown Superior Courthouse. You have a status at the Hacienda Justice Court alleging you failed to comply or failed to pay some fines from a previous assault charge in 2023. I'm not appointing an attorney, but you may hire one if you would like. You're going to have a hearing in the Hacienda Justice Court August 26th at 9 a.m. I am going to release you today on your own recognizance. That is your promise to appear at these hearings. You do have written conditions of release. You are not to possess or consume any drugs without a valid prescription, and you're not to drive a motor vehicle without a valid driver's license. This will be in your paperwork, sir. Did you have any questions?
No, ma'am.
If you'll take a step to your left, the officer will get that paperwork for you. Mr. Nunez to the podium, please. Can I get your name and date of birth?
George Nunez, August 31st, 1999.
Thank you, sir. It does look like you are here today on a warrant from the state of California. They have indicated that they want to extradite you back as it relates to this charge. They have alleged you committed the offense of homicide and issued a warrant on July 31st of 2026. Did you get an opportunity to review the laminated card that was given to you?
Yeah.
Okay. So you're going to be given a choice today. Your first option is you can say, yes, California, I'm ready to be extradited back to California as it relates to these charges. If you were to do that, you would be held here in the Maricopa County jails, non-bondable, and you would be giving them 30 days to come pick you up. That 30 days would start tomorrow, as long as you don't have any pending charges here in the state of Arizona. If you do have pending charges, it'll start at the conclusion of any case you have pending. Or in the alternative, you do have the right to demand that the governors of both Arizona and California sign a governor's warrant before you are ordered to return. In that case, I would set a hearing here in Maricopa County, August 17th at 1:30 p.m. That hearing is civil in nature. So what that means for you is I cannot appoint an attorney to represent you on the case here but you could hire one at your own expense if you would like. That process takes about 60 to 90 days. In that case, you are eligible for a bond. You do have a secured appearance bond in the amount of $3 million. In the event you posted that bond, you would be released, but it would still be your responsibility to ensure that you attended all of your hearings here in Arizona. If you failed to appear at any hearing here in Arizona, a warrant would issue for your arrest here in Arizona. You'd still have a warrant in California, and you'd forfeit the bond you posted. Do you know what option you'd like to do here today?
Regardless, still have a warrant out in California, right? Still gonna get sent over there.
Can you say that a little bit louder?
Regardless, I'm gonna still get sent to California, right?
Well, not necessarily. You do have the right to demand that the governor of both states sign a governor's warrants to determine whether or not you are required to be returned. So you can waive that and say, I'm just willing to go, or you can go through the process. Again, that process takes about 60 to 90 days. And at that time, it will be determined whether or not both governors are going to sign that warrant ordering you to go back. And I don't know if they will or not.
I'll just do the first one.
So you're willing to waive your rights and say you're ready for California to come pick you up? Okay. Since you are doing that, I am going to ask you some questions. You are waiving some very important rights. And then at the end, I'm going to get your signature. So again, I just want to confirm you did get an opportunity to review the extradition paperwork. That was the laminated card that was given to you?
Yes.
And do you understand that you do not have to sign this paperwork?
Yes.
And do you understand that you have the right to the extradition hearing? That's that hearing I would schedule on August 17th at 1:30?
Yes.
And do you understand that you have the right to hire a lawyer at your own expense?
Both options was I had to hire them on my own expense.
For the hearing here, because the hearing here is just whether or not you should be extradited back to California, you're not entitled to court-appointed counsel here in Arizona. As it relates to your criminal charges in California, California may appoint you counsel, but you're not entitled to court-appointed counsel here in Arizona as it relates to whether or not California will pick you up or not.
Okay. Yes.
Okay. And do you understand that you have the right to demand that the governors sign a warrant from both states before you are returned?
Yes.
And do you understand that you have the right to bail in this case? That was the $3 million bond.
Yes.
And do you want to give up those rights and sign this paperwork?
Yes.
And has anyone threatened you or promised you anything to get you to sign this paperwork?
No.
And have you had any drugs, alcohol, or medication in the last 24 hours?
No.
I find that you are knowingly, intelligently, and voluntarily signing this waiver, and I'm also going to sign it. I'm going to direct the sheriff's office to let California know that you are ready to be picked up. They will have 30 days from tomorrow to pick you up, so long as you don't have any other cases pending in Arizona. If you do have any cases pending in Arizona, then the 30 days will begin at the conclusion of that case. Did you have any questions for me?
No.
All right. So I am going to sign the paperwork, and then in a moment, I'm going to have you sign on the pad right in front of you. You do have to push hard, and we're going to need a couple signatures, but if you can wait till the clerk tells you that she is ready. Do it slowly. Pressure. Then one more time for the next form. You always make sure. All right, the officer is going to hand that to you, and then you can head to the gallery, okay?
All right.
All right, and we will proceed with our last two cases once we get an opportunity to clear the courtroom. So I do appreciate everybody's patience.
Your Honor, I'm gonna have them sit out there. And
Okay.
we can start.
Appreciate it. Thank you. We good? Wonderful. Thank you. Can I have David Reeves to the podium, please? Good morning. Can I get your name and date of birth?
Last name is first name Davis, date of birth 8/22/73.
Thank you, sir. And counsel, can I get your appearance for the record?
Yes, good morning, Your Honor. David Campbell with DM Cantor. Our office has entered a limited scope of representation for the purposes of this hearing only.
Thank you, Mr. Campbell. And can I get the state's appearance for the record?
Thank you, Your Honor. Brooke Gaunt on behalf of the state.
Thank you, Ms. Gaunt. Sir, we are here today on a new case. It is for 3 counts of sexual abuse, a Class 5 felony. And Mr. Campbell, did you want to be heard today on probable cause, release conditions, or both?
Briefly on both, Your Honor.
Okay. If you would like to move forward on probable cause first?
Yes, Your Honor. Just as it relates to probable cause, we've not had an opportunity to see this video that's alleged in the Form 4 here. However, based on Mr. Reeves' recollection, he is adamantly denying any of the alleged conduct happening in this case being intentional or knowingly. If there was any contact, which he does not recall specifically, it would have been accidental or incidental to his work functions. Other than that, Your Honor, I can move on to release conditions.
Thank you, counsel. I'll give the state an opportunity to respond as it relates to probable cause.
Thank you, Your Honor. I would point the court to, let me see if I can find it in the Form 4. I believe that there is information that the victim reported that Mr. Reeves said you didn't mind, or something to that effect. You didn't mind the first time. And so I certainly think that statement gives the inference that it was done intentionally or knowingly rather than by an accident, as Mr. Reeves is claiming. Additionally, I think there is sufficient information, other information in the report, in the Form 4, to find probable cause on all 3 counts, Your Honor.
Thank you, Ms. Gaunt. And I did take an opportunity to review the Form 4 before I came in here today. I do note the state that the state is referencing, or the statement the state is referencing. I do believe there is enough information here today for purposes of probable cause, so I am going to find probable cause for purposes of today. I do note that you filed a limited notice of appearance. I am going to find that your client is indigent and appoint an attorney to represent him at a future hearing. However, of course, if you do move forward with hiring counsel, they'll file the proper notice. If you're unable to do so, then you will meet with your public defender at your next hearing, okay? Next, we're going to discuss any release conditions and bond that you may have, and then we'll set some hearings on this case. And so, Mr. Campbell, as it relates to release conditions, what's your position?
Yes, Your Honor, we'd be asking that Mr. Reeves be either released OR or, in the alternative, with the $25,000 secured appearance bond rather than a cash-only bond. He is not a flight risk by any means. He has no priors. He has no prior failures to appear. He has lived in Arizona the vast majority of his life. He does not have a passport. He owns a home in Peoria. He has lived in that home for 10 plus years. He does have a partner who he also lives with. He has been with his partner for going on 12 years at this point. They have lived together for going on 10 plus years. He has family in the state of Arizona. His brother is the one who made contact with our office to secure our appearance today. So he has clear family support, connections to the community. He has worked in his job at the Arizona Lottery, going on 7.5 years now. He's not had any issues in his employment status. There's never been any breaks in employment. As far as dangerousness goes, the state did note in their recommendation, generally a lack of significant criminal history, a lack of dangerousness overall. I concur with all of those things. Essentially, there's no prior felony convictions. He's got no substantial misdemeanor record. He was not on probation. He's got no significant juvenile record. There's no indication that he owns a firearm. There's no indication that he's violent or has any sort of domestic violence history or anything of that nature. This appears to be his very first brush with the justice system. And again, he is denying all conduct in this case being in any way, shape, or form knowing or intentional. So for those reasons, Your Honor, we would be asking for an OR release, or in the alternative, a secured appearance bond in the amount of $25,000 rather than a cash-only bond.
Thank you, counsel.
Thank you.
And Ms. Gahn, I did get an opportunity to review the written recommendation. Was there anything you wanted to place on the record or add to that?
Yes, Your Honor, the state is asking for a $25,000 cash-only bond along with electronic monitoring as is required by statute. I would point out to the court, this offenses occurred while Mr. Reeves was working, as well as in a public place, which gives the state additional concern regarding danger to the community. This is an offense that is sexual in nature, and the state would disagree with Mr. Campbell's characterization of this as not violent. The allegations are that Mr. Reeves grabbed the victim's breast multiple times. The state certainly thinks that that is a violent assault, especially given the sexual nature. There, as I indicated in my recommendation form, there is strong evidence as there is a video of the assault. We are concerned that Mr. Reeves is a danger, and we do think that that cash-only bond is necessary to protect the community. Thank you.
Thank you, Ms. Gahn. And I have taken an opportunity to review everything, including the criminal history. I do appreciate the arguments that were provided by both sides. I do note that it does appear as though you do lack a criminal history. This does appear to be your first offense. However, I do have some concerns as it relates to the allegations in this case and the seriousness of them. You're not eligible to be released today on your own recognizance because of the alleged crime does require at a minimum electronic monitoring. So taking everything into consideration, I am going to release you with a secured appearance bond in the amount of $25,000. In the event that bond is posted, you will be released to the supervision of pretrial services and equipped with electronic monitoring. I am going to set 2 hearings coming up. You will have a status conference August 12th at 8:30 and a preliminary hearing August 14th at 8:30. You do have written conditions of release. You're not to return to the scene of the alleged crime. No contact with any alleged victim, complainant, or witness. This will all be included in your paperwork. And Mr. Campbell, did you have anything further?
No, Your Honor. Thank you.
And Ms. Gaunt?
No, Your Honor, thank you.
Thank you. And Mr. Campbell, we're going to get the release conditions printed. We'll give you a copy, but feel free to use that room to speak to your client if you would like, okay?
Excellent. Thank you, Your Honor.
Thank you, counsel. And if I could have Abram Cuadras to the chair, or excuse me, to the podium. Good morning. Could I get your name and date of birth?
Abram Quadras, March 12th, 2007.
Thank you, sir. And I do apologize for mispronouncing your last name. And can I get your appearance for the record?
Good morning, Your Honor. Todd Romero on behalf of Abram J. Quadras.
Thank you, Mr. Romero. And can I get the state's appearance?
Thank you, Your Honor. Brooke Gahn on behalf of the state.
Thank you, Ms. Gaunt. We are here today on a new case. It is for 10 counts of sexual exploitation of a minor, a Class 2 felony. And counsel, did you want to be heard today as it relates to probable cause, release conditions, or both?
Both, Your Honor.
Okay. If we go ahead and start with just probable cause at this time.
Your Honor, cases I've had similar to this in appearing here in IA court. One thing that I noticed is that it's the detective in this case who's opining on the age of these images and what he's viewing. He's not qualified to make those type of statements. Normally, in a case like this, what I see is the detective interviewing the medical expert, and the medical expert will opine about the images that are described in here. I think that what needs to be established here in this case in order to find probable cause in this case. So on that basis, Your Honor, the fact that the detective is not qualified, does not have that experience. I know he says in the reports that he's been in a room where a medical expert has opined on these type of images, but that's a medical expert who's done that, not the detective. In this case, the detective is trying to make those conclusions. I don't think that he's got the expertise to do that, Your Honor. For those reasons, we'd ask the court to find that there's no probable cause.
Thank you, Mr. Romero. And Ms. Gaunt, as it relates to probable cause?
Thank you, Your Honor. I think as defense counsel said, there is some information in here that this detective has additional training experience maybe than a patrol officer or another type of detective in having been present when a qualified medical expert is reviewing the child sexual abuse material in other investigations. The other thing I would point out to the court is that, the counsel's argument might be more persuasive if we were talking about images that included post-pubescent victims. But in this particular case, there are allegations of infant and toddlers appearing. And I certainly think that for probable cause purposes, this detective has enough training and experience to recognize that an infant or child and what their physical appearance is a minor. So I think there is enough information here for the court to find probable cause. Thank you.
Thank you, Ms. Gaunt. And I have reviewed the allegations in this case. I've reviewed the Form 4. I also do note that the detective does list his training and experience. I also do note that this is not an issue of whether or not the child is prepubescent or not based on the allegations that they are infants in at least some of these videos. So I do believe we have enough for purposes of probable cause today. So I am going to find probable cause here today. And counsel, I do note that your notice of appearance is for all further proceedings. I just want to confirm on that.
Yes, sir.
Okay. So I will not appoint counsel since you have hired an attorney to represent you. Next, we're going to discuss any bond release conditions that you may have. Before I do that, I do want to hear from everybody in court. Mr. Romero, I'll start with you.
Thank you, Your Honor. Your Honor, cash-only bond should be the exception. The fact that Mr. Quadros has no prior criminal history, he had no drug history, no criminal history. He's lived here in Arizona his entire life, born and raised. He lives with his mother. We're asking for a $50,000 secured bond. And again, Your Honor, you can impose a combination of conditions to make sure that he'll appear in court. He's not a flight risk. I understand the seriousness of these charges, and so does Mr. Quadros. But Your Honor, there isn't any reason why he should not be released under pretrial services with conditions.
Thank you, counsel. And Ms. Gaunt.
Thank you, Your Honor. The state's asking for a $100,000 cash-only bond, along with electronic monitoring, no contact with any minors, and no internet use. Mr. Quadros was in possession of more than 300 images of child sexual abuse material. As I have already referenced in regards to probable cause, some of these images included infant-aged children. There is strong evidence in the case as Mr. Quadros made admissions to law enforcement about viewing child sexual abuse material. And of particular concern and danger to the community for the state is that the Form 4 does indicate that there is a family friend that has an infant-aged child who frequently visits Mr. Quadros' residence. Obviously, we are concerned about him having contact in the future with minors. Additionally, there is a risk of flight, given that if he is convicted as charged, he will be serving an extremely lengthy mandatory prison sentence. Thank you.
Thank you, counsel. And I just want to review one last thing in the Form 4 before I make my decision. I'll be just with you in just one moment. Okay. All right, thank you guys for both of the information. Again, I have reviewed the Form 4. I've also reviewed the criminal history in this case, which does appear to lack. It doesn't appear that there's any prior criminal history, and I have taken that into consideration. I do have some concerns regarding the allegations in this case and the seriousness of these allegations. I do believe there's a strong weight of the evidence based on the information that has been provided. But in addition to that, something particularly concerning was the information regarding some comments or chats that were made related to young children that were listed in this Form 4. And for those reasons, I have decided to set a secured appearance bond in the amount of $100,000. In the event you post that bond, you will be released to the supervision of pretrial services, and you'll be equipped with electronic monitoring. You'll also have written conditions of release. You are not to have contact with any minors, and you are prohibited from accessing the internet through any electronic means. You're going to have 2 hearings coming up. You're going to have a status conference, August 12th at 8:30, and a preliminary hearing, August 14th at 8:30. This will all be included in your paperwork. Mr. Ramiro, did you have anything further?
No, Your Honor, thank you.
And Ms. Gaunt?
No, Your Honor, thank you.
All right, that does conclude this hearing. We will get you guys a copy of the release conditions, and counsel, feel free to utilize that room to talk to your
All right, thank you, Your Honor.
Thank you. This does conclude our 8 a.m. calendar, and we will now stand in recess until 11 a.m. All right.
Okay, thank you very much, everyone. Please be seated. All right, good morning again, everyone. This is the 11 o'clock initial appearance calendar for August 7th, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. Prior to calling people to the podium, I'd like to read the victim's rights advisement. If you are a victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, dignity, and respect, the right to a speedy trial, the right to be present in court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. And with that, if I can have Bernardo Shaman to the podium, please. And I understand we have the interpreter on the line.
Yes, Your Honor.
Okay. Can you announce?
Martin
Please.
Hernandez, court interpreter.
Thank you very much. To the court interpreter, the defendant is standing at the podium. Sir, could you please give me your full name and date of birth?
Bernardo Santamaría Chamán, 22 de febrero de 1984.
Bernardo Santamaria Chaman, February 22nd, 1984.
Thank you. Sir, you are here today as a result of a new matter stemming from the Maricopa County Superior Court. The count against you is for allegedly one count of aggravated assault as a Class 3 felon. As to that count, the court does find probable cause to exist, and I have appointed an attorney to represent you. Your next court date is a status conference on August 12th, followed by a preliminary hearing on August 14th, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, the court does find that this offense allegedly used or allegedly was commissioned with the use of a box cutter, also allegedly in a public location. The court considers this to be a safety risk to the victim and the public as a whole. As such, the court is imposing a secured appearance bond in the amount of $25,000. Should you be able to post that bond, there are additional release conditions which will apply. You are not to return to the scene of the alleged crime. You are not to initiate contact with the alleged victim in this matter. You are not to have any physical contact with the alleged victim in this matter. You are not to initiate contact with the arresting officers. You are not to possess any weapons. You are not to possess or consume any drugs without a valid prescription. You are not to possess or consume any alcohol. You are not to drive a motor vehicle without a valid driver's license. You are not to leave the state of Arizona. And you must notify the court of any new address. A copy of all of your release conditions, as well as all of my orders, are going to be provided to you in writing. If I can have you step to your left, please, to collect your paperwork.
Okay.
Thank you.
Thank you.
If I can have the court interpreter make a general announcement to see if anyone else needs the services of a Spanish-speaking interpreter.
Yes, sir. Buenos días a todos. Soy el intérprete para esta sesión. Si hay alguien más en la sala que necesita intérprete de español, por favor levante la mano ahora.
The officers have indicated to me that no one has raised their hand, and with that, I thank the interpreter for his services here today. You may be excused.
Thank you, sir.
If I can have Ashley Cruz to the podium, please. And Rodrigo Beltran to the chair next to the door. It's number one that the state's going to come in. Yes. Okay. All right. Good morning, ma'am. Please give me your full name and date of birth.
Ashley Cruz, 82794.
Thank you very much. Ma'am, you're here today. Yeah, you're here today as a result of two different matters. The first matter is a new matter stemming from the Maricopa County Superior Court. It is for allegedly one count of possession of drug paraphernalia as a Class 6 felony. I have found probable cause as to that count. I have appointed an attorney to represent you. Your next court dates are as follows. You have a status conference on August 12th, followed by a preliminary hearing on August 14th at 8:30 in the morning. The status conference is also at 8:30 in the morning. And that's going to be, all those are going to be followed by a evidentiary hearing on August 14th at 1:30 in the afternoon. All three settings are going to take place in the downtown Superior Court. As to your release conditions on this matter, whenever, pursuant to statute, whenever anyone, not just you, is on felony release for one matter and is alleged to have committed a new offense, that person is to be held non-bondable. I do find that you were on felony release for CR 2026-109018. As such, for this matter, I am going to be holding you non-bondable. As to your second matter, that is the matter that I just talked to you about. It's a matter stemming from the Maricopa County Superior Court for one count of possession of dangerous drugs, a Class 4 felony, and one count of possession of drug paraphernalia, a Class 6 felony. I have appointed an attorney to represent you in this matter. Your next court date is a status conference on August 12th, followed by a preliminary hearing on August 14th, both at 8:30 in the morning, both in the downtown Superior Court. As to your release in this matter, the court is imposing a secured appearance bond in the amount of $500. I'm sorry, in the secured appearance bond in the amount of $1,000. Your previous release conditions were a $500 bond. Obviously, those were not enough to secure your appearances at future court dates. And with that, the court is imposing a $1,000 secured appearance bond. Again, you have no bond on the other matter. Should your release conditions change, there are some additional release conditions that would then apply. I'm not going to go over those with you here today, but they're going to be included in the paperwork you're about to receive. If I can have you step to your left, please. Rodrigo Beltran, please, to the podium. Colin Jones to the chair next to the door. Good morning, sir. Please give me your full name and date of birth.
Rodrigo Beltran, September 28, 2003.
Thank you very much. Sir, you're here today as a result of an arrest warrant stemming from the Maricopa County Superior Court for your open felony matter, which is 1 count of aggravated assault as a Class 3 felony, 1 count of disorderly conduct as a Class 6 felony. You already have an existing attorney representing you, so I'm going to go ahead and affirm that the representation from that existing attorney. Your next court date is a status conference on August 17th at 8:30 in the morning in the downtown Superior Court. As to your release conditions in this matter, the court is very, very concerned about the fact that you were issued a no contact order in relation to the alleged victim in this matter. However, the allegations are that you have had at least 3 continued contacts and therefore harassment of the alleged victim. Court feels that this poses a danger to the alleged victim. As such, the court is going to be affirming a previously set bond in your matter as a result of the issuance of the arrest warrant. It's a cash-only bond in the amount of $25,000. Should you be able to post that bond, I'm also going to order that you be outfitted with an electronic monitoring device, also known as an ankle bracelet, prior to your release. And again, you are not to return to the scene of the alleged crime or have any contact with the alleged victim in this matter. The rest of your release conditions are going to be provided. I'm not going to go over it with you here today, but they're going to be provided to you in writing, along with all my orders. If I can have you step to your left. Colin Jones to the podium, please. Caitlin Swisher to the chair next to the door. Good morning, sir. Please give me your full name and date of birth.
Colin Ray Jones, 4/16/92.
4/16/92. Thank you very much. Sir, you're here today as a result of a new matter stemming from the Maricopa County Superior Court. It is for allegedly 1 count of aggravated assault as a domestic violence related offense, as a Class 4 felony, 1 count of unlawful imprisonment, also as a DV related offense. Now, this one is a Class 6 felony, and 1 count of assault and 1 count of disorderly conduct. Both of those are Class 1 misdemeanors. As to all counts, the court did find probable cause to exist. I have appointed an attorney to represent you. Your next court date is a status conference on August 12th, followed by a preliminary hearing on August 14th, both at 8:30 in the morning, both in the downtown Superior Court. As to your release conditions in this matter, the court does note the fact that you have at least 1 prior felony conviction, also for aggravated assault. The court is very concerned with the allegations that the alleged victim in this matter has demonstrated physical injuries consistent with strangulations and being struck repeatedly. With that, the court is imposing a secured appearance bond in your matter in the amount of $35,000. Should you be able to post that bond, I'm also going to order that you be outfitted with an electronic monitoring device